Good afternoon, everyone. Welcome to the first session of the Jurisprudence Discussion Group of Michaelmas term 2022. This term we have a few changes. First, there's a new convening team. Myself, I'm Javier, Angelica over there, who's doing the recording today, and Trenton over here. And also, starting this term, all sessions will take place here in this room. We're moving to unit from Valio. This is the Arthur Goodhart room, which has some symbolism to it, because as you know, Arthur Goodhart was master of unit, but he was also professor of jurisprudence. He held the jurisprudence chair for 20 years, right before H.L.A. Hart came in and changed everything. I want to, before we get to today's event, I just want to make a few announcements. So first, I just want to get you all invited to our next session next week, Thursday, at 3 p.m. here. Right, we're gonna have a more a sort of seminar set up this time because it's a book launch. We decided to have this theater set up, but next week we'll have a seminar set up. There's no registration needed, just show up. It's a very interesting paper by Victor Tadros on consent next week. Also, announce to you that this Friday at 2 p.m. there's a philosophy, law, and politics colloquium. Right? They're having Leah Murphy in All Souls at 2 p.m. So I understand you have to register on the website of the Philosophy, Law, and Politics colloquium. And thirdly, I want to draw your attention to this little events card that you have with you alongside our JDG term card. This event is for a different initiative. It's called Philosophy, Law, and Politics Graduate Forum. Right? It's where it's a platform where graduate students present work on philosophy, law, and politics, and they receive comments from students who are members of the students committee and from faculty members. So if you're interested, please check that out. If you want to receive the invitations for these are online events. If you want to receive invitations, just log into the website. It's right there, and then join into the mailing list. Okay, so on to today's event. We're having a book discussion of Julie Dickson's Elucidating Law, which was just published this year. So what we'll do is that we'll have Julie here with us, professor of jurisprudence here in Oxford, to present the main ideas of the book for 10 to 15 minutes. And we didn't decide on the order, but who wants to go first for comments? Verónica, would you like to go first? Okay, so we have Verónica then. Give some comments on the book. She came from Surrey, 15 minutes, and then we'll have Tom Adams from here, from Oxford, and there's a handout for Tom's comments for another 15 minutes, and then we'll turn back to Julie so that she can, respond for another 10 minutes, and then we'll open up for Q&A for around 30 minutes. So we should be wrapping up at about 6:30 p.m. And as you can see, right at the foyer, there are some wine and some water, so we can have some mingling after the session. Okay, so thank you all for being here. And without further ado, Julie, the floor is yours.
Thank you. Good afternoon, everyone. Thank you, Javier, for that introduction. And thank you more generally to this year's organisers of the Jurisprudence Discussion Group, Angelica, Javier and Trenton, for inviting me to this first session of the academic year to talk about my book, Elucidating Law. It's both a pleasure and an honour to be here. A few years ago, I was fortunate enough to be invited to an event celebrating the 20th anniversary of the Jurisprudence Discussion Group. And although, at least for me, time seems to have gone all weird since the whole pandemic business, I think it won't be long before we're coming up on the 25th anniversary of the group. And the JDG has been, in all that time, just an immense achievement, consistently hosting so many wonderful speakers and events. I don't claim this is one of them, but the track record is fantastic. And without any doubt, the JDG benefits all of us jurisprudents in Oxford and far beyond. And I just want to say it's something the Oxford postgraduate legal philosophy community should be incredibly proud of. While I'm doing the thankings, I'd also like to thank Verónica and Tom for agreeing to be commentators today. I admire their work so much, and I know I'll learn a lot from their comments. Unfortunately, too late to improve anything in the book, but there's always hope for the future. And also to thank all of you for coming along, and I know I'll learn so much from your questions and comments as well. And just honestly, finally on the thankings, I want to thank all the editors of the series that the book has appeared in, which is the Oxford Legal Philosophy series with Oxford University Press. Timothy Endicott, who is with us here today, I'm delighted to see him. Les Green and John Gardner all helped me enormously with this project over many years, and I quite possibly wouldn't have started it, let alone finished it, without them. Timothy, as I said, is here with us. As you know, so sadly, John is no longer with us, and Les is now retired and based in Canada. But I want to thank them all, and when we have the drinks reception after the event, I certainly will be raising my glass to absent as well as present friends. Okay, so, to the book. I do like the cover and how it looks. I'm not equivocal at all about that, then it's into something else. So, the book Elucidating Law, it's about the methodology of legal philosophy, or we might say about the philosophy of legal philosophy, which is to say it addresses questions like what are the aims of legal philosophy, what can it hope to achieve, what are its criteria of success, how should legal philosophers approach and engage with their subject matter, and what constraints are incumbent on them as they do so. Which questions should the philosophy of law seek to address? To what extent are different jurisprudential explanations of the same phenomena compatible? Can there be progress in legal philosophy? Does the discipline have a finite or a never-ending task? Now, I raise and discuss several of these questions in the book, but I don't offer conclusive answers to all of them, and maybe not to any of them. And to an extent, although it may sound like a cop-out, and it maybe is, I'm comfortable with that. That is, I'm comfortable with raising and discussing questions in quite an exploratory, non-conclusive way. And as well as the kind of main sort of narrative, I suppose, running through the book, I think of it as having a number of side projects. And one of them is this, to suggest that I think we might benefit in legal philosophy from more discussions which are kind of speculative and exploratory, rather than discussions where the author claims to have everything nailed, and where those who disagree take as their task to fire holes in the things that the author says they have nailed. So, the book overall focuses on one part of legal philosophy that I call legal philosophy about the nature of law. And in its early chapters, I try really briefly to outline and kind of render plausible the idea that one important part of legal philosophy correctly conceives of itself as seeking to identify and explain the nature of law. Now, I don't say that that's the whole of legal philosophy, or even the most important part, just that it's one important part. And I try to make sense of what various legal philosophers might be talking about when they claim, as many legal philosophers do, that their theories explain the nature of law. That is, those properties which make law into what it is, and without which it wouldn't be law. And as I do that, I try to outline, again, it's very brief and preliminary work in the book, I try to outline what I call a domain apt, and if you like, a metaphysically non-heavy duty, or a metaphysically modest, perhaps, understanding of what it is to search for and seek to explain the nature of law. That one that is apt to our explanandum, law, being something that is created, sustained by the actions, intentions, attitudes, etc. of human beings and their social institutions. And as well as trying to outline that, what various philosophers of law might be best interpreted as saying when they say they're trying to explain the nature of law, I also engage with some other legal philosophers who very much doubt that there can be an account of the nature of law, or doubt that law has a nature that any account can correctly explain. And I tried to show that some of the apparent clashes between those who doubt and criticise that there can be an account of the nature of law and some of those who argue that there can be an account of the nature of law, I tried to show that maybe some of those clashes, apparent clashes, might be built on misunderstandings of exactly what those claiming to have developed an account of the nature of law are claiming. And that's kind of another side project of the book, to try to lessen misunderstandings between different traditions and approaches in legal philosophy. For example, perhaps between sociology of law and philosophy of law, between radically critical approaches to understanding law and not so radically critical approaches. I think in the profession there's quite a lot of failure to understand what those on the other side of allegedly disciplinary boundary fences are doing. Not that I'm a fan of disciplinary boundary fences, as I try to talk about as well in the book, but I sometimes feel people kind of sort of hurl vague kind of brickbats over the fence at what they think those on some perhaps other side are saying. But whether they really are saying that, it isn't always clear. And I think it would be good in general if we could lessen the misunderstandings that lead to this kind of thing. Not in a kind of, hey, then we can just all get along, but in fact, so we can be clearer about exactly where we do disagree with each other and where we don't. So that's what I do in the beginning of the book, the first in chapters sort of 1 to 3. And then from chapter 4 onwards, I move more into my own methodology of legal philosophy that in this book I call indirectly evaluative legal philosophy. And I'll just pick out some themes from that here to give a flavour, and it will only be a flavour in the time that I have. And also I'm much more interested in what Verónica and Tom have to say than what Blessing and myself waffling on. So in chapter 4 of the book, one of the themes, I try and explain my view that even for those engaging in legal philosophy about the nature of law, the questions and puzzles of legal philosophy are multiple, diverse, plural, changing, arising and alter over time in response to our changing interests and changes in the phenomena in the world that we seek to understand. And I try and explain what are the kind of mechanisms of this question or puzzle or issue pluralism. What drives what I see as a diversity and developments in the questions that legal philosophers ask. And I also try to explore in what ways do theorists exercise choice as regards what they choose to explain and how they choose to explain it, and what constraints might be incumbent on them as they do so. The second half of the book, chapters 5 to 8, then takes us further down the road toward my own particular methodology of legal philosophy. And I think of each of chapters 5 to 8 as explaining what I think of as certain constraints on a successful theory of law, or perhaps various methodological precepts that I think should be adhered to by legal philosophers in constructing and defending their theories of law. Chapter 5, for example, discusses two of these constraints, namely, one, the need to do justice to what I regard as a certain duality running through law's nature, to do justice both to law as a social fact and to law as a normative phenomenon, however we should understand that latter. And I also argue in chapter 5 that another sort of methodological precept that I think is viable to adopt is that we as legal philosophers perhaps want to consider, and there are good reasons to consider, approaching law with what I call an attitude of due wariness. There's a kind of sort of a standing suspicion of law running through the methodological approach I take. A standing suspicion given the moral and other risks and dangers that law can run and can realise, and the scale and effects of what it can do. Chapter 6 then discusses another constraint on a successful theory of law's nature, which I think is the need to do adequate justice to the self-understandings of those living under law. And this leads me to try to argue that because of that need to do a certain kind of justice to those self-understandings, that there are important limits to the possibility of revisionism as regards a theory of law, and particularly as compared with theories of other phenomena. And I should perhaps say that as well. I view the things I say in this book about methodology as being driven by the character of law as a distinct kind of phenomenon. So I'm not making a claim that things I say that I think are the right way to approach understanding law transfer to other concepts, even other concepts in in political philosophy. They're kind of law specific, or that's at least as far as I'm willing to argue at that point. But in that chapter, I look at work of Nikolaos Stavropoulos, who we have here today, and of Mark Greenberg, both of which, especially Greenberg, I kind of take as playing a bit too fast and loose with existing self-understandings in terms of law. And I try and illustrate through Greenberg's work what I think is problematic about a theory of law that is significantly revisionist, that ends up significantly at odds with aspects of our common understanding of law as a phenomenon. Chapter 7 returns to some ground that I covered before in my first book, 20-something years ago now, Evaluation in Legal Theory. So that chapter 7 talks about evaluation in legal theory, talks about the role of evaluation of various kinds in a successful theory of aspects of law's nature. And I try and make the case for adopting an approach that I refer to as staged inquiry, not as in, just only occurred to me, they're not as like sort of faked, but in stages, wherein we postpone making certain morally evaluative judgments about aspects of law until a later stage in our theories of law, and where we stick in the earlier stages of inquiry to what I term indirectly evaluative judgments, which pick out and focus on features of law that are important and significant to explain without yet taking a stance on the moral value and or justifiability of those features or of law as a whole. While doing that, I do want to emphasise that I think legal philosophy is evaluative through and through, and that legal philosophers need to make evaluative judgments of various kinds to do their job well. The question for me, though, is what kind of evaluative judgments do we need to make, at what point in the inquiry, and in which order? And I know, because they both gave me a sneaky heads up before I came, that Verónica has lots of really interesting, challenging things to say about this. And then finally, chapter 8 tries to bring out aspects of the link between, if you like, the kind of early stage part of my approach to legal philosophy, the part where we seek to identify and explain aspects of law's nature without yet making morally evaluative judgments about them. I try to explain the link between that and the later stage of the inquiry, in which we are free to, and I think we should want to, consider questions such as what are those moral and other values to which law should aspire, in light of which it should be judged, and questions like whether and under what conditions law succeeds in living up to those values. And part of the idea of that chapter is also to do with the side project of listening to misunderstandings, is to try to answer the criticism that's sometimes mounted that an approach to legal philosophy which is, if I can say, is non-morally evaluative in the early stage of the inquiry, that it is thereby dry, sterile, uninteresting, hermetically sealed off from, otherwise uninterested in, the kind of really juicy questions, like what am I to do, what shall I do, and questions about law's moral value and justifiability, whether we should obey it, etc. I'm interested in those questions, and I think everyone should be, and I'm not advocating a theory of law that's uninterested in them. I just advocate that we get to those questions slightly later in stages of inquiry and after asking and attempting to answer certain other questions about law's character. But I very much think there are links between the different stages. So that's a potted kind of run-through overview of the book, and I heard enough of myself definitely already, so I leave it there, and I'm looking forward to the comments.
Thank you very much, Julie. We turn to the comments now. We'll start with Verónica. Thank you.
Well, thank you very much. It's a real pleasure to be here in the Jurisprudence Discussion Group. Thank you very much, Angelica, Javier and Trenton, for this invitation. It is an absolute privilege for me to comment on Julie's book, Elucidating Law. So Elucidating Law is an impressive piece of work from a scholar who has dedicated her life to advance our thinking on how we should theorize about law. This is not a small achievement, as it requires both a solid understanding of how the law works and a firm grasp on the complex literature of legal philosophy. In her new book, Julie focuses on the philosophy of legal philosophy. Her contribution is significant and rich due to her insightful views and careful argumentation. In my judgment, the most important idea of elucidating law is her defense of a key distinction between directly evaluative judgments and indirectly evaluative judgments in legal philosophy. The arguments that ground this distinction are the focus of chapters, as she will pointed out, 6, 7, and 8 of the book. Now, I would like tonight to scrutinize one key underlying premise of her distinction and challenge it as the ground of the demarcation between legal philosophies that involve direct and indirect evaluation. So this premise is that there is a reality of law that determines its nature, that is objective, though mind-dependent. If this is true, therefore, the first task of the legal philosopher is to determine this reality, namely the nature of law. After determining this reality in terms of picking up the features that are important and relevant, it is argued we can proceed to evaluating it. By contrast, the two key philosophers who have defended what she calls direct evaluation, Finnis and Dworkin, think that either practical reason or constructive interpretation provides the ground for the reality of law. According to Dworkin and Finnis, there cannot be two stages of inquiry about the nature of law, as the reality of law either is generated, so to speak, by practical reason or is constructed via legal interpretation guided by integrity. The problem that arises for Julie's view is how we can grasp this reality and pick up the relevant features. Julie does not believe that the reality of law is like the reality of water, Gödel's theorem, or rocks. It is a social reality, she tells us, that depends on the self-understanding of the subjects involved in the respective social practice, namely law. Thus, the legal philosophy data or explanandum is, Julie tells us, quotation, a citation, attitudes, beliefs, actions, and intentions of those who create, administer, and live under the law. However, this is where the complications start. If self-understanding means knowing that I'm doing X and not Y, then it seems that we need to explain self-understanding in the particular way that we as rational creatures engage with the world, namely from the first-person perspective where acting and deliberating takes place. The way in which human beings engage with the world is radically different from how non-human animals engage with the world. Non-human animals do what they do without trying to make sense of what they are doing. By contrast, human institutions and practices such as law, family, estates, art, literature, and so on depend on our making sense of them. They cannot be built, changed, and sustained unless we answer the basic question of what their point or meaning is. But the way we try to give them meaning or make them intelligible is very peculiar and particular. Once we are engaging with any human practice or institution, for example, exercising the function of a judge or following a statute or legal directive as citizen, we are trying to settle an answer to the question, what shall I do? In order to answer the question what the law is or what this or that institution is. Similarly, when we engage with short, medium, or long-term ends, for example, writing a poem or forming a family, we are trying to settle an answer to the question, what shall I do? In the context of the law, for Finnis and also for the Dworkin of Law's Empire, there is no reality outside the confines of our making sense of what we are doing. Let me refine the challenge in the following way. In my judgment, what both Finnis and Dworkin share is what I would call the plight of the inexorability of the normative stance. Thus, the normative stance is not Hart's internal point of view. It is rather, in the case of Finnis, the robust point of view of practical reason. In the case of Dworkin, it is the point of view of being guided by integrity, which enable us to construct the best possible interpretation of past legal material. This means, For Dworkin and Finnis, there is no point outside of our seeking or the making sense of our activities and engagement with the world when we are acting and deliberating. Furthermore, for theorizing to be successful, it needs to explain the normative stance. Consequently, the explanation of economists, historian, or sociologist needs to account either in a reducible or non-reducible manner for the normative stance. If Finnis is right, then law should be seen in continuity with practical reason, and consequently direct evaluation is inevitable. Let me reformulate the challenge as follows. If there is a reality that is what the law is, then there is something contrary to that reality. This means that there is something that is not law. To make it more scrutable, we can work the problem in terms of propositions as follows. Let us suppose proposition A, that it says, if there is a true proposition of law Q, then there ought to be also a false proposition of law not Q. Imagine that there is a legal rule Q that establishes that if D negligently injures P, then D ought to pay damages to P in order to put P in the same position as if the wrong has not been committed. Q is true in the English legal system. Julie tells us the legal philosophy needs first to ascertain whether Q is true, and then she can proceed to evaluate Q. The question is, what will be the contrary or the false proposition of this legal rule? The false proposition will be not Q, which states, it is not true that Q, if D negligently injures P, then D ought to pay damages to P in order to put P in the same position as if the wrong has not been committed. But the puzzling matter for Finnis and Dworkin is this. Once the philosopher has determined the truth of Q, there is no reality that enables us to distinguish Q from not Q. We can only distinguish Q and not Q via either practical reason or constructive interpretation. In other words, they will be presented as options to our practical reasoning. There is no reality that settles the question, what shall I do, to answer the question, what is the law in this particular case, that is independent from your seeking to settle the question. This is so because at no point will we find a social reality, qua-social reality, when we are acting and deliberating. We will not find facts or features qua-facts that are part of the legal practitioner's practical reasoning. We cannot therefore pick up features that are relevant and important without deliberating. To be more precise, the social reality will be transparent and in the background, of course, but not present in the legal participant's practical reasoning when she selects the relevant features. So the legal participant will not say, here is a social institution, the law of negligence, created by our concept of law. Furthermore, it is because of my beliefs and attitudes towards that concept that I ought to pay damages to D as if the wrong has not been committed. In other words, from the point of view of the first-person perspective, the legal practitioner engaging with the law will not find social facts that are not normatively latent and that will help us to distinguish Q from not Q. The philosopher of law's task, according to Finnis, is to trace and grasp the richness and complexity of the first-person perspective. Dworkin will tell us that there are underlying principles in the legal material, and Finnis will say that the truth of Q is determined by a judgment of practical reason in terms of the key values at stake. In other words, Finnis and Dworkin, as adherents of the plight of the inexorability of the normative stance, believe that we need to establish whether Q is intelligible or makes sense or has good-making characteristics or presents law in its best light. Because as citizens, lawyers, or judges, we need to answer the question, what shall I do? This could be done either on the basis of practical reason and the values embedded in the law, or a la Dworkin via constructive interpretation. In a key passage, Julie quotes Hart, who states, why not show law in its worst light? The answer is that from the first person or normative stance, It does not make sense to answer the question, what shall I do, in terms of bad-making characteristics. For example, D ought to retaliate P against P for the injury that she has negligently caused, or in terms of the worst reading of the legal material, or in terms of something as unintelligible. For example, D ought to compensate P for the injury that she has negligently caused only if the act was committed on a Tuesday. If we aim to deliberate an act, we need to make intelligible our action. We need to make sense of our actions. We need to advance the description of the action in terms of good-making characteristics. Arguably, we could object to the correctness of the plight of the inexorability of the normative stance and say that the strength of Julie's position is precisely in distinguishing the descriptive social level, which presupposes a theoretical stance, from the evaluative stage, where both the deliberative or normative stance of the legal participant and answering the question, what shall I do, is predominant. However, my point is that these two stages are not at the same level. They're not accounts of the same reality. Thus, the first person or normative stance is prior to any theoretical stance or non-normative stance in case of normative practices. Julie's reflection on the distinction is important and a progress, but I wonder whether it is a sound distinction since it is based on the mistaken presupposition that the theoretical and practical perspectives are at the same level. Julie provides the following example to illustrate her distinction. She tells us that there is a dress code attached to sitting examinations at the University of Oxford. She advises her students regarding the academic formalities, including the need to wear the mask for taking finals at Oxford, without considering whether these formalities are good or bad. However, a directly evaluative theorist will say that her advice to the students from the second person point of view is parasitic to the first person point of view. The second person and the first person perspectives are not at the same level because the former is parasitic on the latter. Let me explain. The statement that you ought to wear the sub-mask for your final exams presupposes an evaluative or normative premise. This means a premise that is seen as good or making sense or making intelligible or emphasizing the good-making characteristic of the action in terms of the question, what shall I do, that the student poses to herself. The premise might be something along the following lines: to follow the academic dress of the institution displays respect for the history and for the institution. This premise is part of the advisor's practical reasoning if she is engaged with certain institutional values. But it might be that the advisor assumes the following premise: it is good to follow the academic dress code of the institution to avoid sanctions or embarrassment. In this case, the advisor is alienated from the central case of the good-making characteristic of the action, but still the formulation is in terms of good-making characteristics. She's at the margins, but her judgment nevertheless presupposes a normative stance. The example precisely shows that it is possible to provide advice without understanding how the action makes sense, is intelligible, or has good-making characteristics. The idea of the plight of the inexorability of the normative stance means that an evaluative or normative stance is always required for action, for giving advice on actions, and for criticizing potential actions. Let me give you the following metaphor to further illustrate my point. Julie believed that you can enter a gallery of paintings and contemplate them in two different ways. First, you can assess whether they are paintings and ascertain the brush techniques and other matters of art, or even select some features that are important and relevant for further assessment without knowing whether they are good or bad paintings. After this, she will tell us, we can proceed to evaluate whether the paintings are beautiful, worthless, ugly, harmonic, expressive, and so on. Evaluation can be indirect, Julie will tell us, because it comes after we have ascertained the reality of the painting and selected certain features. By contrast, Theories who favor direct evaluation will say the following. Law is an activity. It is not like entering a gallery to contemplate paintings. Therefore, it is more like being thrown into a gallery, being given brushes, a canvas, a paint, and being asked to create a painting. You need therefore to ask yourself, what shall I do? Should I create a landscape painting or a human figure? And then you need to ask yourself, why? And the answer to why will impregnate the how of the action. Therefore, there is no contemplative or theoretical stance because you need to deliberate and decide what to do. The nature of the painting is determined by the way it is creating, which is inevitably evaluative or normative, i.e., either via practical reason or constructive interpretation. In the context of the law, similarly, we are asked as legal participants to either follow the rule, directive, or principle, and as a judge, we are asked to advance a response to the question of what the law is in terms of an answer to the question, what shall I do? The philosopher of law does not have a privileged position because she is immersed in the activity called law, and she is obliged to understand the answer to the question, what shall I do, to illuminate what the law is. As some key passages of chapter 7, Julie seems to agree on the plight of the inexorability of a normative stance. She states, we do not fully understand law unless we understand those values and ideas to which it aspires. Directly evaluative theorists would agree with this sentence, but she would add that the full understanding of these values and ideas involved engagement of our practical reasoning. She theorizes qua practical reasoner. This does not mean that there is in this direct approach no demarcation between good and bad law. It is only that we need to understand what good law might look like to understand bad law and make intelligible the distinction between them. My criticism of Julie's distinction does not reflect the many key issues on which Julie and I are in complete agreement. The book displays sound and well-grounded ideas as an important contribution that will leave a mark on jurisprudential thinking. The book is an essential reading for scholars in the field and lawyers who wonder how we should theorize about law. Julie has shown that legal philosophers can make general jurisprudence accessible and interesting. She has also shown that general jurisprudence truly matters.
Thank you very much, Veronica. We turn to Tom.
Great, thanks. Thanks, Angelica, thanks to Javier, and thanks to Trenton for this. It was great to sit down and be able to read your book, Julie. Really, I thought it was incredibly careful, concise, thought-provoking, and an important addition to the literature. So, a lot of the time when people think about philosophy, they think about a bullfight or something like this, scrapping in the ring, winner takes all. And I'll do my best if I, minimize your contribution as best I can and maximize mine as best I can. And Julie's work shows that philosophical progress happens actually by taking on a model which is in polar opposition to the one I've just described. So Julie's approach, I think, is much more ecumenical, if not entirely collaborative. Julie has her views and those that she strongly disagrees with, but she wants to, in this book journey, I think, as far as is possible with others to understand their position on the best terms, and only when necessary, and only when all possible misunderstandings are cleared out of the way, does she show where she thinks they go wrong. And in that way, that way of traveling with others, I think, is a really important aspect of a good philosophy, and it's really represented in the book. And the further thing which I really like about the book is the way that Julie is willing to say, well, I'm not entirely sure about this issue, or this is where I want to leave this question for now. I think people think, sometimes that good philosophy is philosophy that closes off question or shuts down possibilities, and I think this book shows precisely why that's not true as well. So I think this is the kind of philosophy which gives others confidence to their own philosophical work on the questions that it considers. In that regard, it's a great thing. It's sort of philosophy as a generous conversation rather than philosophy as a bullfight. So there's lots in the book, lots I could have talked about, but I'm going to have to confine myself here, I think, to sort of two two aspects which I thought were particularly interesting, and this is the very early part of the book. So what Julie says about what it is to make claims about the nature of law, and also something about the place of self-understanding in the theory of law. I'm going to try and say something about each of those. So first, on making claims about the nature of law. So Julie says that one part of legal philosophy should take as its task the identification and explanation of the nature of law. An account of the nature of law, we're told, will be general in character, and such an account will explain those properties law must possess in order to be law, i.e. those properties that make law into what it is. This is all on your handout. So Julie makes clear that this account here is not an account of legal philosophy in toto, right? So as Julie makes clear, the philosophy of law is about much more than what some of us would call general jurisprudence, what Julie calls legal philosophy about the nature of law. So there are many important philosophical concepts that we might be interested in as legal philosophers that aren't going to fit into an account of the nature of law. So concepts local to particular areas of law, for example, the reasonableness standard in tort law, the notion of strict liability. So no one thinks that for a legal system to be a legal system, it must regulate certain aspects of social life in terms of the reasonableness standard, or for a legal system to be a legal system, it must contain strict liability standards around certain issues. But of course, there are really important philosophical issues that relate to these concepts, and they form a core aspect of legal philosophy. But, Julie says, and I agree here, not part of an account of the nature of law. So, general jurisprudence does not provide a sort of gatekeeping approach with regards to what are the major philosophical questions within jurisprudence more broadly. There are, I think, here though some tricky questions about whether certain forms of legal regulation, certain areas of law might actually form a necessary part of legal systems. I'm thinking here about constitutions, perhaps also I'm thinking about the role of sanctions in understanding the nature of law. So Kelsen famously thought both that all legal systems necessarily have constitutions, and all forms of legal authority trace themselves back to the historically first constitution, and that all legal systems necessarily contain sanctions. And by thinking that, he brought various aspects which some might consider part of sort of special jurisprudence into the remit of general jurisprudence, and whether he is successful here depends upon the veracity of his arguments. But I think there are complications and wrinkles here. Nonetheless, I think Julie's core point still holds. Right? So perhaps Kelsen's right, and perhaps in some sense, constitution is necessary for the existence of law. But that doesn't mean that everything that we might think of as part of the philosophy of constitutional law is therefore part of our general jurisprudence, right? So maybe no legal system can exist without a constitution. But it's quite plausible to suggest that the constitution could exist without constitutional rights. Yeah? And if that's true, an important aspect of the philosophy of constitutional law, what does it mean for people to have constitutional rights, is not part of our general jurisprudence, despite the fact that there's a connection between these two different areas. So legal philosophy about the nature of law, or general jurisprudence, does not set boundaries to the philosophy of law. On this, I'm in total agreement with Julie. And another point that she makes, which I think is important, is that general jurisprudence doesn't exhaust the important theoretical questions that we might have about law as a kind of institution. So think about the following example, right? So the Pope, perhaps it's necessary to be the Pope that you're the head of the Catholic Church. So that might be one necessary condition for someone fulfilling the role of pontiff. But of course, knowing that doesn't tell us anything about the political importance of that institution today, or about the character of those who fulfilled the role in recent times. All very important aspects of understanding the institution, but at the same time, not necessary truths about what it means for someone to take on the role. So recognizing that legal philosophy about nature of law, jurisprudence, is concerned with necessary truths about law doesn't mean it's a gatekeeper of all that's important. about law as a form of social institution. So on this too, I'm in total agreement with Julie. So general jurisprudence concerns philosophical questions about the nature of law, but that doesn't tell us all that's important philosophically about law, nor does it tell us all that's important about law as a form of social regulation. So having sort of set out the view, Julie moves to discuss a number of challenges to this way of thinking about legal philosophy. And one of the most important that she considers is that this task is in some sense impossible because it involves what Julie calls sort of metaphysically extravagant presuppositions. And in particular, the idea that understanding necessary truths about law would commit us to the notion that such truths are a priori and hold in all possible worlds. So in response to this, Julie says that perhaps we should not jump to the conclusion that legal philosophers seeking to explain the nature of law seek to do so in some a priori manner without reference to experience of the social reality of law, or view them as making claims that they regard as true in all possible worlds, human or no. I think I want to push back a little bit on this idea here. The idea that we can make claims about the nature of law, that is, claims about law's necessary properties, but that these properties need not hold across all possible worlds. So it seems to me difficult to sort of separate these different bits of the apparatus. So going back to the earlier example of the Pope. So if it's necessarily true that the Pope is the head of the Catholic Church, it would seem to me to follow from that there's no world in which, if we have a Pope, that they are not head of the Catholic Church. And if we have a world in which, there is no head of the Catholic Church, that's a world without popes. And it also seems to me right to say that this truth, that the Pope is the head of the Catholic Church, is not one that's based upon our experience with popes. We don't sort of survey them one by one as they come along and then draw the inference from that, these guys must all have been doing this job, and therefore this is part of the nature of the papacy. Instead, it seems to me that the question of whether or not the person we have in front of us is, in fact, an example of the right type, well, that's going to depend upon the nature of the institution. And how do we have knowledge of that? Well, I think I'd like to say we have a priori knowledge of that fact. Why a priori? Because it's analytic. It's a truth grasped by understanding the sense of the concept involved. So it seems to me that these are a package deal, or at least there's a very plausible story to be told that these are a package deal. And I'm just sort of interested in why, Julie, why you want to prize them apart, or whether the real issue isn't the sort of misunderstanding of what's implied by these facts on the part of those on the other side of the ledger. I wonder here whether you're not being slightly too charitable to those on the other side of the ledger. So that's my first question. So if we're committed to understanding the nature of law and its necessary properties, why aren't we committed to what most people would consider to be the standard implications of such a view? Okay, so that's issue one. Issue two concerns self-understandings and their place in the theory of law. So Julie says that to understand the nature of law, we must understand our concept of law, and I'm in full agreement with that. And indeed, I might even say that to understand the concept of law is to grasp or understand the nature of law, and that there's no important distinction between these two different ways of speaking. I think it would be strange to say, well, the concept of the Pope means that, only those who are the head of the Catholic Church really are examples of the right kind. But say, well, and then there's this further question. What is the nature? What is the nature of the papacy? I think I'd want to say that these are two different ways of talking about the same issue. Second move that Julie makes is to note the way in which legal concepts, central legal concepts, feature in our self-understanding. So she says that those living under law refer to, use, and frame things in terms of the concept of law and related concepts when they talk about, think about, engage with aspects of their lives in society. And the final move that she makes, and this is the one where I might have some questions, is to say that our self-understanding should therefore be given a certain degree of weight when we come to construct our theories of law. So Julie says we should grant weighty explanatory significance to the self-understandings of those who live under law, because in the case of law, those self-understandings form a vitally important part of the data we seek to explain, such that explaining our self-understandings in terms of law is explaining aspects of the nature of law. And I suppose I have some questions about, if not the approach, then the framing of the approach here. So when I was reading this passage, I was thinking about the amount, the extent to which I suppose what you describe here about legal concepts could also be ascribed to the role of moral concepts in our lives. So it seems to me obviously true that moral concepts feature in our self-understandings, our understanding of ourselves in relation to each other. These all form a really important aspect of our conception of ourselves in the world. But the moral self-understandings of people, sort of in the moment, often collapse into a sort of crude individualism or relativism about moral concepts. Well, there's no real moral truth, just my view versus yours, or at best, the arbiter of moral truth is something like the community.
Speak for yourself. Some of us are not.
And now, well, I think the most obvious response to this sort of view about the limits of morality and our meta-ethics is to show how these sort of crude aspects of our self-understanding are actually completely inconsistent with the way in which we use moral concepts as parts of our discourse. So our use of moral concepts, I think it's pretty obvious, commits us to the idea that certainly we can be wrong about moral issues, and the same can be true of all of those around us, and in fact so can entire communities, and that there could be moral progress beyond that which we can even really contemplate right now. I think the grammar of our moral language already commits us to all of these possibilities, at least their coherence. And in this case, it seems as though in a face-off between, what is it you'll say about morality if quizzed in the moment, and these deeper facts about the structure of our concepts, their logic, what they presuppose and what they imply, I want to go with the latter as opposed to the former. And just as we can have sort of massive self-misunderstandings about morality, and I think we do, I think the same can apply to law. So I think it's plausibly true, for example, that most people believe that judges shouldn't make law, and that rather they should just decide cases authoritatively. And, well, there's a question here about the coherency of that thought, right? But this seems to me to be a widespread view about law, something which is, part of the popular self-understanding of at least a certain section of the American public, the British public too, as examples. But it seems to me to be an obviously wrong part of that self-understanding, and something that jurisprudence should stand ready to correct. So I think jurisprudence can help us to make sense of our self-understandings. I don't want to say that it should ignore them, but it should illuminate them when they themselves say something important about the nature of law, and when they contain contradictions or distortions, we shouldn't be beholden to them. Now, there's a section of the book which I think might contain what you might say in response to me on this, and this has to do with the idea that self-understanding shouldn't be understood in the vox pop way. Yeah. Okay. So Julie in the book is pretty clear that when she talks about self-understandings, she doesn't mean getting someone with a microphone in the street and recording. Well, tell me what you think about the nature of law. Tell me what you think morality is really about. That's not what self-understandings mean. So she says, the self-understandings of those living under law are more implicit and diffuse than vox pop notions connotate. Such self-understandings are manifest in the aspects of the use made of legal rules by those engaging with them, for example, what those people find important or unimportant, and the distinctions that they draw. So perhaps then my examples, both from morality and law, are to be thought of as vox pop and correctable in light of deeper facts about how we use concepts. But I wonder here whether there isn't now a sort of tension in the model, because what we're saying is that certain aspects of our self-understanding are going to stand to be corrected in light of other aspects of our self-understanding. And it seems to me perhaps a little difficult to call the latter aspects of our self-understanding, because it actually takes a lot of work to bring people around to abandoning these sorts of ideas, and often they'll push, very understandably, against the attempt to do so. So there's a lot of resistance to, for example, to bringing people around to recognizing that aspects of their moral language might commit them to something more in the way of moral truth than what I say and what you say. And I think the same could plausibly be said of legal concepts. So my big question here is, why characterize that latter aspect of what's going on as a matter of our self-understanding rather than as a matter of the basic concepts that we operate with in the domain, or something like this? So should we really be describing our concepts, our language, and our social structures as aspects of our self-understanding, especially when the truths implicit in these can go, I think, far beyond, indeed might even be inconsistent with our folk theory or vox pop understandings of the institution. So these were a couple of areas in the book, having read it, where I thought I wanted to sort of hear more from you around them. But to be honest with you, it was quite hard to find, because I found the book so clear and compelling for the most part that it took a while to dig around to find these. So thank you.
Thank you very much. Now, Julie, you can respond.
Okay, well, there's so much in both of those amazing comments that I try to say in teaching and to my students when I write all the annoying comments on their essay, that one should always think of it as a compliment when your work sparks so many more questions, and when people are, feel motivated to engage with it in depth. And I tell you what, I feel the reality of that with these comments. I'll just maybe try and say a couple of things briefly about each, because we want to leave time for the audience to come in as well. Or maybe that'll just happen in the course of the response. Okay, so if I start with Veronica's, some of Veronica's points. Just to be, this is sort of a devil's advocate, maybe a sort of provocative statement. I think I'm less sure than you are, maybe than a lot of people are, that the primary question in lots of different domains of life, and in understanding phenomena in lots of different domains of life, including legal philosophy, that the primary question is, what shall I do? Right? I think it may just be that I don't get that as the primary question. And when you explained it, you said that you thought that was true even of writing a poem. In writing a poem, I'm asking, what shall I do? I sort of want to make, am I? Are we? Is that always the question we're asking? So I didn't push this in the book because I wanted to say that I think my approach to legal philosophy can focus, facilitate, etc., asking questions about law's moral value, about what we should do in light of it, about our practical reasoning, and I do think that. But as it happens, I also think if we were just to be interested in understanding the character of a very important phenomena in our social lives and our social world, that's all pervasive, that's everywhere, without getting to the question, what shall I do, I would be okay with that, and I think that has value in itself. And if I put it provocatively, lots of people in here doing lots of research, writing theses, etc. Do all of your theses answer the question, what shall I do? And if they don't, does that make the work the less valuable? And I might be over-pushing it here. Even if some of those points hold, I take the point, and I'm the one, I made it as well, that I think what I'm saying is specific to law. We might think there's a stronger case for what shall I do being a extremely important question when we're trying to understand law. Namely, because law is in the business of telling us what we ought to do, it's coming at us with claims over us that we ought to do, it consists of normative phenomena that takes a stance of what we ought to do, etc. so that if we don't try to understand that, we'll be missing something about it. And I agree with that, but I don't think my approach precludes it. It just says we're going to get to those questions, what ought I to do as a practical reasoner given the presence of law, later. Right? We're going to get there in a bit. Now, you're right that presupposes that there's something to do earlier, my kind of terminology. And that's where your other point comes in about there isn't a social reality of law there for us to grasp independent of answering the practical reason question or constructively interpreting law or something else that implicates quite deeply moral value judgments, etc. And my kind of instinct is that there is something there, and I'll try and say a bit of what I think it might be. So, one reason why I think that I'm only talking about the methodology of legal philosophy in this book is that I think law has a social reality to it that differs from even other concepts that we might study as legal philosophers or as legal and political philosophers. So, in thinking about the character of equality or dignity, or to some extent maybe even authority, or I see these perhaps on a spectrum, your point seems more kind of plausible to me. But law, to me, has a different character from those things, not just in terms of the domain of value, alleged value that's trying to operate in, or etc. etc. Law is an institutionalised normative system. Now, I might just think that's begging the question or asserting my view. Law is out there in the sense that every place that has it has institutions, has officials, has enforcement, has norms that are not just the result of human deliberation in general about what I ought to do, but that have a kind of factiness, a there-ness about it. And that's kind of behind my instinct as to why I think what I say is specific to law. So it's the kind of institutionalised normative qualities. And at one point when you were talking about whether the legal reasoner or the legal advice giver, I can't remember what they would say about tort law, I was sort of tempted to say, well, they wouldn't resile to their first personal understandings of what ought I to do or what would be a good-making characteristic of tortious liability. They look at the cases. They're there. There were institutions that have decided these things. So I think there is a there-ness. Law is not a theoretical construct. I mean, it's not something that theorists introduce to help their thinking about the world. It's got a there-ness to it, and we find out if we get on the wrong end of it, if it takes our benefits away or says we can't live in the council house with an extra bedroom without putting financial penalties, or condemns us because of our sexuality, or it's not the specifics of these examples, but the thing that does these things does it in particular ways, through institutions, through norms that can be identified by their connection to institutions, that characteristically and perhaps essentially might come with enforcement. So that is the kind of there-ness to me that puts law in a different position from theorising about other concepts in moral and political philosophy, maybe. So, yeah, I want to mention that. And just one thing about the worst light, heart and the worst light. I really like that quote. You said a couple of things I thought were really interesting. The examples you gave of putting law in its worst light were kind of examples of interpreting a legal norm or a putative legal norm in a way that's intelligible or not intelligible, like the negligence standard founds duty of reparation only on Tuesdays or something. But that kind of thing I don't think is what someone like Hart has in mind when he thinks about the worst light, or me. He has in mind things that are more about the general systemic character of law. So because it's administered by institutions and by officials, because it deals with millions of people at a time, it perhaps has a standing risk that it can become alienated from those people, that they feel it's something imposed on them from outside. Or because it categorises people and then channels social power along the categories, it can bring about absolutely devastating consequences in people's lives, especially when it does that at scale and with coercion behind it. So it's these kind of things I think that Hart has made by saying it's not to render it unintelligible, it's to see that there might be things in the nature of law that are standing moral risks, or that make it something that is a threat to us. And I just want to leave room for that side of things, I guess, in the way I'm thinking about the inquiry, if that makes sense. Oh yeah, and just a final point on that, I wanted to say, you said that if you ask what are the bad-making features of a phenomenon, then you can't ask the first personal practical reason deliberation questions, what ought I to do? But I think you can. Surely you can ask, you can say, should we get the heck rid of it, law, if it has these terrible morals? Or should we be very wary about what we extend it to and put serious limits on the domains of life it's allowed to intrude into, because it's just not very good at it. So I think you still can, I think, ask first personal deliberative questions that bring out the bad. And I want to leave room for that in the theory that the approach to legal philosophy I'm trying to emphasise.
Yeah, thank you, Julie.
I don't think.
Yes, okay, that's
mainly.
fine. Yeah. I think in the mail we can
Okay,
do this
yeah, I
conversation.
found that
Thank
really
you so
helpful.
much. Yes, thank you.
Oh goodness. Yeah. So yeah. I didn't see myself as making a positive claim that there are no a priori truths in legal philosophy, or that no one should be seeking for them. And part of that's just to do with the way the structure of the argument works, is that I'm just not trying to do that. That would be extravagant and way beyond my capacities. As in, I'm not trying to set out a theory of the nature of reality and the conditions of our access to it, not even in the domain of law, not trying to do that. So the argument in that bit of the book is quite ad personam. So I think your second interpretation is right. I look at how people characterise theories of law that claim to be about the nature of law, and they tend to say some pretty kind of extreme things about it. It's around page 38, 39 of the book. So in a way I'm kind of saying, maybe every single thing that counts as legal philosophy about the nature of law doesn't have to have all these characteristics that persons who doubt its possibility ascribe to it, rather than saying positively myself exactly what it is. And that I don't even try to do that, might be a weakness, but I thought that was biting off way more than I could possibly choose. So I kind of work within the discourse of what people already say to try and show that some of it's way overstated. And it's easy to make something look silly if you hold it to a totally inappropriate standard, or you kind of either or it. Either the law is like the H2O, or just something that we. So I thought that was more what I was trying to say there. And on self-understandings, I'll just say it is a cop out. So I try and as a cop out as an answer. It might be a cop out in the book as well. In chapter 6, I try and a little bit of depth at least to explain what it is that legal philosophers do with already existing common understandings that people hold in terms of the concept of law, and what it is that I think they shouldn't do with them. So I try and tease that out in a way that goes beyond just pop or do something else with that. So I try and go into that. And I do it through particular examples because I thought it was quite important to sort of show it rather than just talk about it in the abstract. So there's a bit more in chapter 6 on Tom's excellent point, I put it that way, that people can have a look at, and obviously free to decide that it doesn't do sufficient of the work that it's supposed to be doing. I think of self-understandings or understandings in terms of the concept of law as kind of anchor points or constraints on what a theory of law can do. So it's not that we have this question of weight, it's not we either slavishly lift and follow them, or we just say we're free to move beyond all that to some deeper phenomenon. I also think there's something dubious that the idea that it will be a deeper explanation that transcends how people understand themselves in terms of law, but that's a larger story. So I try and do it in terms of examples, but what I'm acutely aware of with this point and with the whole book is that I also believe that which is the correct methodological account can't be determined sort of on purely methodological grounds. So the real way to do it would be to show it. It would be, for me or someone more talented than me, to right to try and come up with some people have a theory of aspects of the nature of law that use this methodology, and the kind of proof of the methodological pudding is in the substantive theory eating kind of thing. And I haven't done that here, and it's a limit that I come up against quite a lot in the book. But yeah, I just tried to show through an example what we might mean, what we can do with how people already conceive of law, in a way that we don't just slavishly lift our vox pop it, but nor do we feel entirely free to be so revisionist that we end up with an account of law that would render as not law things that people may think of as central cases of law or something like that. Anyway, I'll shut up there.
Please join me in thanking Julie.